Hello and welcome. So, you're a Canadian and you're thinking about buying property in the United States. It's a fantastic idea, but you absolutely have to know that the rulebook is completely different south of the border. In this explainer, we're going to unpack some expert legal and tax advice that could literally save you from making million-dollar mistakes. You know, whether it's that dream vacation home down in Florida or maybe an investment property over in Texas, the pull of the US market it's really strong. But that dream, well, it can turn into a genuine nightmare if you're not ready for the cross-border complexities.
And I'm not getting dramatic here. The common sense assumptions that many Canadians make about how to own U.S. property, they can lead to just devastating financial and legal consequences. We're talking about things like double taxation or even having your assets totally frozen for years. So consider this your map through that minefield.
All right, so here's our game plan. First, we're going to tackle the single most important question you have to answer. Then, we'll get into your ownership options, and I'll show you a huge U.S. tax trap to avoid. After that, we'll put together your essential cross-border legal kit. And finally, we'll even look at how this investment could become a path to a U.S. visa.
Okay, so you found the perfect place. Amazing. Now, the very first question, before you even dream of signing any papers, is how are you going to own it? This one decision, right here, sets the stage for pretty much everything else.
And every single strategy for ownership has to be measured against these two critical factors. First, liability protection. Let's say someone slips and falls on your property and decides to sue you. Are your personal assets back in Canada safe? And second, the tax consequences. How is your ownership structure treated by both the IRS in the US and the CRA in Canada? Because believe me, getting this part wrong can be unbelievably expensive.
So how do we get that balance right between protection and taxes? Let's dive into the legal structures. We're going to break down the most common options, and I'm going to show you exactly why the structure that is so popular for Americans can be an absolute train wreck for Canadians. This quote right here from cross-border lawyer Michael Kennedy just hits the nail on the head. So many people have heard they need to set up a limited liability company, an LLC. And look, it's a fantastic tool if you're an American resident, but for a Canadian, it can be a serious trap.
So here's the heart of the issue. In the United States, an LLC is typically a flow-through entity. The profits just flow directly to the owner's personal tax return. Easy, right? Well, the problem is, Canada's CRA looks at that exact same LLC and sees a corporation, and that fundamental mismatch is a recipe for double taxation. The limited partnership, or LP, on the other hand, solves this. Why? Because both countries see it the same way, as a flow-through. That consistency is absolutely crucial.
So you might be wondering, okay, but how does an LP give me that liability protection I need? It's a really clever two-part setup. You've got limited partners, that's you, the investor. Your liability is limited, just like a shareholder in a big company. And then you have a general partner. This is the entity that actively manages the LP, and here's the key. It holds all the liability.
So, how do you make sure the general partner is protected? Well, you'd never want an actual person in that role. Instead, you create something called a special purpose vehicle, or an SPV. Just think of it like a dedicated legal container, a liability shield. Its only job in the entire world is to be the general partner. It holds zero assets. So if the partnership ever gets sued, all that legal risk gets trapped inside this empty corporate box, completely shielding you and your personal wealth. Pretty smart, right? Okay, let's say you've got your ownership structure perfectly sorted. Awesome. But there's another huge risk just lurking in the shadows, one that a lot of Canadians have no idea even exists until it's way too late for their family. I'm talking about the U.S. estate tax. Just look at this. The difference in how you're treated is just staggering. A U.S. resident can pass on almost $14 million completely tax-free, but a non-resident, and that includes a Canadian, gets a tiny exemption of only $60,000. Any U.S. assets you own above that tiny amount are on the chopping block. And the tax rate? It's a brutal 40%. And here's the real kicker. That's calculated on the gross value of your U.S. assets, not the net value. So, a $500,000 condo with a $400,000 mortgage is still valued at the full $500,000 for estate tax purposes.
Now, okay, there is a bit of a safety net. The Canada-US tax treaty offers relief, and it can bring your exemption way up to the same level as an American's. But, and this is a huge but, it is not automatic.
To get that relief, your estate has to file a U.S. estate tax return. And to do that, you have to disclose the value of your entire worldwide assets to the IRS. A lot of people are understandably not comfortable with that. But if you don't file, you're stuck with that tiny $60,000 exemption. And even if you end up owing zero tax, the process itself can be a total nightmare. In a lot of states, like Florida, for example, you can't sell or transfer the property until you get a tax clearance certificate from the IRS. And as Michael Kennedy points out, the backlog is so bad that families are waiting for years. Imagine that, unable to touch their inheritance, all while still having to pay the mortgage and the upkeep on the property.
This moves us from the world of taxes to really crucial legal planning. Your ownership structure can handle liability and taxes when you pass away, but what happens if you're still alive, but you can't make decisions for yourself anymore? Just picture this for a second. You and your spouse own a property in the U.S. together, and one of you has a stroke or maybe develops dementia. You decide it's time to sell the place, but the incapacitated spouse can't legally sign the documents. What do you do then? This is a massive warning, and you need to hear it loud and clear. You might think, oh, my power of attorney from Ontario will cover me. It will not, I promise you. U.S. title companies, banks, lawyers, they will not recognize it. Without a valid state-specific U.S. document, your family is looking at having to go to court just to get a guardian appointed. That's a process that is long, it's public, and it is very, very expensive. And this is exactly why it is non-negotiable to have a separate set of U.S. legal documents. At the absolute minimum, you need a power of attorney for the state where your property is located. But ideally, you'd also have a state-specific will to make the probate process smoother and a healthcare directive if you're spending a good chunk of time down there.
All right, for our last section, let's switch gears and explore something really interesting. How a U.S. real estate portfolio can, if you play your cards right, be more than just an investment. It could actually be your ticket to living and working in the United States.
This happens through what's called the E2 investor visa. Because Canada has a treaty with the U.S., Canadians who make a substantial investment into a U.S. business can actually qualify to live in the States to run and direct that business.
Now, the two key words there are active business. Just owning a single-family home you rent out on Airbnb, that's seen as a passive investment, and it's not going to cut it. You have to show you're running a real commercial enterprise. That usually means owning multiple properties, maybe larger multi-unit buildings, or getting into related stuff like property management or flipping houses. You'll need a formal business plan, and your investment has to be considered substantial. There's no magic number, but it has to be a serious, significant amount of capital.
So as we've walked through all of this, it's pretty clear that buying property in the U.S. as a Canadian is a whole different ballgame than buying a cottage up in Muskoka. It really demands a shift in your whole mindset. You have to start thinking like a sophisticated international investor. And that means proactive legal and tax planning isn't just a nice to have, it is absolutely essential for protecting your investment and your family.
So we'll leave you with this question. If you already own property in the U.S., or if you're on the verge of buying, take a really hard look at your strategy. Is it truly set up to protect you from all these pitfalls? Answering that question right now and getting help from cross-border experts could save your family an unbelievable amount of money, stress, and heartache down the road.